welcome you all to the practitioner series that we have started to connect people from across the fraternity, students, practitioners, activists, lawyers to the first hand and primary experience of the veterans and legendary members of the bar and ask them to share their experience and what they have learned throughout their journey while practicing as lawyers. And today we have a very special guest with us, Senior Advocate Rebecca John, ma'am. I would provide a brief introduction, but before that, I welcome ma'am to our practitioner series. I can't think of anyone else who would be better suited to talk about this topic than you, and we are very blessed to have you on the panel today. Uh, Rebecca ma'am was designated as a senior advocate in 2013. She was enrolled with Bar Council of Delhi in 1988, and she has been practicing exclusively on the criminal side in the Supreme Court of India, High Court of Delhi, and in the trial courts of Delhi for the last more than 3 decades. She has conducted a wide range of criminal trials and appeals dealing with offences under the Indian Penal Code, special statutes like Unlawful Activities Prevention Act, Prevention of Corruption Act, Prevention of Money Laundering Act, and among others. Over the years, she has represented accused persons as well as victims. Among the long list of cases to her credit are the Jain Hawala case of 1996, the 2G Spectrum case, the Arushi Talwar murder case, the Sri Sant IPL match fixing case, the Hashimpura massacre case, the defamation case filed against journalist Priya Ramani, the Ankit Saxena murder case, where she has been appointed as a special public prosecutor, and many others. Rebecca Ma'am is a member of the Internal Complaints Committee of the Delhi High Court, dealing with complaints under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2030. She is also a statutory member of the Delhi High Court Legal Services Authority. I've had the privilege of being the primary witness to the expertise of Ma'am during the MJ Akbar trial, the Daryaganj bail matters, the anti-CAA protesters bail matters, as well as the Nirbhaya writ before the Delhi High Court. And I think it's time we share that gift and share that expertise with all of you. Uh, so we welcome you, ma'am, and thank you for joining us. And the floor is yours now. Thank you.
Thank you very much, Karan. I've had you following some of my cases. I see the keen interest with which you report. So thank you very much for introducing me and for saying this very kind welcome. I'd like to thank Live Law for giving me this opportunity to speak today. Now, as defense lawyers, we defend the rights of accused persons. These rights include the right to a fair trial, the right to due process protections, the right to seek redress or a legal remedy, the right to the presumption of innocence, the right against self-incrimination. Today, I will discuss some of the broad strategies we can employ at various stages of a criminal case. Now, I have divided these strategies into 6 or 7 categories, and these include strategies pertaining to arrest and bail, strategies during investigation, which include strategies during remand, strategies that can be employed to refute the case of the investigating agencies, then strategies during trial. And some of the ones that I would like to highlight are the stage of 207, the stage of framing of charges, and the stage of evidence. I will also be talking about certain residual strategies that can be employed during the journey of a criminal case. Now, coming first to the strategies surrounding bail. As you know, the arrest of an individual by an investigating agency without maintaining fidelity to the statutory safeguards leads to a violation of Article 21, rights of the individual. It leads to the curtailment of the dignity and liberty of an individual in an unlawful manner for which the investigating agency must be held accountable. One of the greatest problems that we grapple with as practitioners is when clients and instructing lawyers come to us and ask us, what is the appropriate time that we move bail applications? As you know, when a person is arrested, he's remanded to custody. Sometimes he's remanded to police custody. When a person is remanded to police custody, Should you move a bail application? Or should you wait till such person is remanded to judicial custody? What is the appropriate time when we should move a bail application, notwithstanding the fact that the person has been remanded to judicial custody? These are some of the problems that we grapple with and we need to strategize about. There are no real clear answers to this, except that I would hesitate to file a bail application when a person is remanded to police custody. And I would generally advise my team and lawyers asking for my advice to wait till the police custody period is over and move a bail application after the person has been remanded to judicial custody. Likewise, if a person has been remanded to judicial custody, do you move a bail application immediately or do you wait for some time? Now, this is a cat and mouse game, and it's not always clear when you should move a bail application. Sometimes the evidence against you is coming out fast and furious, and the advice would be wait till things settle down. Either way, this is a decision which the legal team takes depending upon the facts and circumstances of the case. And there is no real answer as to when you should move a bail application. You can move a bail application before the primary court, look at the nature of evidence against you, just to judge where the investigating agency is taking the case against you. But then wait before you access superior courts, because there is no point moving superior courts if you're pretty certain that the superior courts will dismiss your bail application. Regardless of this, there are certain fundamental principles that practitioners must keep in mind while dealing with bail applications and while dealing with the opposition to bail applications. Now, some of the paramount or some of the grounds for opposition include the fact that the accused may have been an accused in several other cases. 1. 2, that the accused may be guilty of tampering with evidence, and there is every possibility that the accused will tamper with evidence and therefore deny bail. 3, that the accused has not cooperated with the investigating agency while in custody or prior to his arrest, and so on and so forth. Now, these are some of the standard oppositions to bail applications, and we must be prepared to deal with these oppositions in the best possible manner. Now, the law is quite clear whether investigating agencies follow it or not. The law says that simply because an accused has pending cases against him, that is not a ground for dismissal of bail. In fact, the Supreme Court, in a judgment, a 2020 judgment titled Prabhakar Tiwari versus State of Uttar Pradesh and others, has made it pretty clear. This is a judgment of Justice Deepak Gupta and Justice Anirudh Bose, have made it pretty clear that despite the fact that there is gravity and seriousness of the offense, or that there are several cases pending against the accused persons, those factors alone will not determine the outcome of a bail application. And that is not sufficient to deny bail to an accused person. So pendency of other cases is by itself not a factor for refusal of bail. And that must be vehemently argued before a court. Likewise, it is often said that grant of bail will send a wrong signal to society. And I would refute this immediately by quoting a judgment of the Delhi High Court in Firoz Khan versus State, a judgment by Justice Anup Bhambani, where the honorable judge said that if that the remit of the court is to dispense justice in accordance with law, not to send messages to society. It is this sentiment whereby the state demands that under trials be kept in prison inordinately without any purpose that leads to overcrowding of jails and leaves under trials with the inevitable impression that they are being punished even before trial and therefore being treated unfairly by the system. So sending messages to society is no part of the duty of a court, and the court has to look at the facts and circumstances of each case, dehours of the noise and the publicity that the case may have got. In the same way, In another pretty important judgment of the Delhi High Court delivered recently, called Navendra Babbar versus State of Delhi, the High Court took into account one of the grounds for opposition for bail, and that was that the accused had not cooperated with the investigation at the stage of investigation and must therefore not be granted bail because all the evidence against him could not be collected. The High Court said that while the state argues that the applicant has not cooperated in the investigation, the only aspect cited is that the applicant did not give to the IO original documents relating to the offense. And then goes on to say that the IO's allegation that the applicant was not cooperating in the investigation needs to be put in a legal perspective. Is the IO saying that an accused would be taken to be not cooperating in the investigation till he furnishes all materials that the investigating officer thinks is necessary to nail him? We must remember that in our system of criminal jurisprudence, an accused has a right of silence, apart from the fundamental right against self-incrimination under Article 23 of the Constitution. What would happen if an accused says that no material is available, whereas the IO thinks or says that other material exists and must be delivered before he's granted bail? In such a case, would the court be persuaded to keep an accused in judicial custody endlessly till this impasse is resolved? Consider another scenario. What if an accused wants to produce some exculpatory evidence in his defense during trial and fears that if this exculpatory evidence is shared with the investigating officer during investigation, the investigating officer may either not produce such material before the court or destroy it so that it is not available to the accused for his defense? While in theory, it is the duty of the IO to collect all evidence, whether inculpatory or exculpatory, during investigation and to place it before the court, it would be naive for a court to assume that this theory is put into practice by investigating agencies. It is also well within the rights of an accused to bring out defense evidence only during trial. This is one of the reasons why in a criminal trial, an accused is not required to furnish a written statement of his defense, nor to file any affidavit disclosing the evidence he proposes to adduce during trial. The IO therefore cannot be heard to say that till the applicant hands over to him every shred of evidence which the IO thinks exists, the applicant should be kept in prison as an under trial. Now, these are very, very powerful words coming out of a judgment of a court and can be used to our advantage when we are filing bail applications for accused persons. There is no standard rule that simply because there are pending cases against an accused, he should not be granted bail, or that the accused is withholding information, therefore he should not be granted bail. On the contrary, the law is very clear. The law laid down by courts say that an accused has a right not to self-incriminate himself. He further has a right to withhold such information which he thinks the IO may destroy, and he can use at the time when he's either cross-examining witnesses or producing his own defense evidence. So these are some of the standard opposition or standard formats of opposition to bail, which we must be in a position to counter. Likewise, the Honorable High Court of Delhi has said, it is no part of the duty of the court to send any kind of message to society. Courts look at evidence, and if the evidence adds up, then perhaps bail can be refused. But if the evidence does not add up, then bail is the rule and jail is the exception. So these are some of the things that we must keep in mind while arguing bail applications. In another very interesting judgment of the Delhi High Court, passed by Justice Hari Shankar, this judgment is Ashok Sagar versus State. The court has gone to the extent of saying that the seriousness of the offense is not the determining factor for grant or refusal of bail. Now, this is a judgment which is reported in 2018 SEC Online Delhi 9548. And in this judgment, Justice Hari Shankar of the Delhi High Court has stated that incarceration during trial is not punitive, but to secure the presence of the accused. The approach of the court in examining applications for bail which seek release of the accused during trial has therefore necessarily to center around the issue of whether continued incarceration of the accused is necessary and imperative towards securing the end of obtaining his presence when required. Incarceration during trial, therefore, neither chastises nor cures. The court has gone on to say that the nature of the offense committed necessarily has a limited role to play while examining the merits of an application for bail. If the court were to allow itself to be unduly influenced by the nature of the charges against the accused and the seriousness of the crime alleged to have been committed by him, it would result in obliterating the distinction between grant of bail and suspension of sentence. Inasmuch as the applicant in a bail application has yet to be found to be guilty of the offense with which he is charged, the significance of the nature of the offense stands substantially reduced while examining the application for bail. Courts have to be alive to this legal proposition, underscored in the very first paragraph of Dattaram Singh, that every accused is presumed to be innocent until proven guilty. The court went on to say, while examining applications for bail, the court has to be duly sensitized to the mandate of Article 21 of the Constitution of India, which guarantees freedom to every citizen of India, save and except by procedure established by law. Curtailment of personal liberty during trial has therefore to be limited to those cases where it is absolutely essential. I thought it important to highlight these cases because of late, we find the prosecution arguing to the contrary to the ratio of these judgments. And the prosecution repeatedly says that the offense is serious, that the accused is likely to flee from justice or tamper with the evidence of the case, or that it is necessary for the court to send out a message by refusing bail. In fact, none of these arguments have been validated by courts. Courts have given findings to the contrary, where they say that we limit ourselves to certain basic principles, and those principles include whether or not the accused will be available for trial. While we may consider the facts of the case, that is not the sole determining factor. And simply because an accused is said to have not cooperated with the investigation, that is not sufficient ground to deny him bail. Also, multiplicity of cases pending against an accused will be decided on the facts and circumstances of the case, and that is not the sole ground for refusing bail. So these factors must be kept in mind while arguing for bail for an accused person, because these are the typical roadblocks that defense lawyers face while arguing for bail. In a case in which an accused is in custody, the other strategy that can be employed and must be taken care of is finding out whether the accused is entitled to statutory bail or not. So as you know, the Code of Criminal Procedure requires under Section 167, the investigation to be completed within a maximum period of 60 or 90 days, depending upon the offense for which the accused is charged. Clearly, as defense counsels, we must be alert to the fact that the 60th or the 90th day is round the corner. And if indeed by the 60th or the 90th day, as the case may be, the charge sheet has not been filed, then the accused is entitled to statutory bail. And the strategy must be clear. We must move an application at the end of 60 or 90 days, asking for the accused to be released on statutory bail. There is only one there's only one caveat here, and that is that the application asking for statutory bail must inform the court that the accused is ready and willing to furnish bonds. So we must be alert to the timeline, and we must have the application for statutory bail ready at the end of the 60th or 90th day if the police has not filed its charge sheet within the time frame required under Section 167 of the Code of Criminal Procedure. One of the questions which has come up for consideration is whether the magistrate has power to grant bail in a case punishable with life imprisonment, but triable by a magistrate. Now, this question was referred as a reference to the division bench of the Delhi High Court, and it was held that even a plain reading of Section 437(1) of the Code of Criminal Procedure makes it clear that the magistrate does have the power to release on bail a person accused of the commission of a non-bailable offense, subject, however, to the conditions of subclauses 1 and 2 of subsection 1 of Section 437 of the Code of Criminal Procedure. This is a judgment titled Court on its Own Motion versus State 2017 SEC Online Delhi 11099. These are some of the things that we must keep in mind at the time when we file bail applications. Now, suppose our bail applications during investigation, that is within the 60 and 90-day period, has been dismissed. Is that the end of the matter? Or can we revive the bail application after the charge sheet has been filed? So one of the unwritten principles for grant or refusal of bail is the change in circumstance. And very often courts ask, what is the change in circumstance that you've moved to second bail application? The filing of the charge sheet is a change in circumstance because now the case against the accused has been crystallized and the investigation with respect to the offense is over. Clearly, that constitutes a change of circumstance. And once investigation is completed and the charge sheet is filed, by and large, courts will like to relook the evidence against the accused and consider the bail application moved by the accused afresh. Because now you have the benefit of the charge sheet and the statements of witnesses and documents annexed therein. And the court is able to determine whether the police has been able to sustain its allegation, at least on a prima facie basis, or whether the allegations remain largely unproved. Therefore, even if your bail application has been dismissed prior at the stage of investigation, you can very reasonably move a bail application once the investigation is over and the charge sheet has been filed. In the 2G case, in a case which went right up to the Supreme Court, Sanjay Chandra versus CBI, the Supreme Court held that once the charge sheet has been filed, the accused reasonably can seek the benefit of sections 439 of the Code of Criminal Procedure, and bail should be granted, even if the case is serious and of a large or high magnitude. The Supreme Court's reasoning was that now that the investigation is over, the accused is required for no purpose other than facing his trial. And if those conditions are fulfilled and there is no apprehension that he will tamper with evidence or is a flight risk, then bail ought to be granted. So this is the second stage where you can employ a strategy that is post-filing of charge sheet. You can start all over again before the magistrate, before the sessions judge, before the high court, as the case may be. And the filing of the charge sheet gives you an opportunity to revive your bail application, even if it has been dismissed earlier. This is with respect to the strategies surrounding bail and the moving of various applications during this period. Now, the stage of investigation is a very, very critical stage in the life of a case, in the life of a criminal case. And many strategies can be employed during this stage. Typically, the police must produce an arrested accused person before a magistrate within 24 hours. This is on a reading of Section 57 and Section 167(1) of the Code of Criminal Procedure. Once produced before a magistrate, the accused can be remanded to police or judicial custody during the first 15 days. The first 15-day period is an interchangeable custody period. And after the first 15 days can be remanded to further custodies of tranches of 15 days each, but not beyond the maximum limit of 60 or 90 days as the case may be. unless, of course, the investigating agency files its charge sheet during the statutory time frame. Now, what are the strategies you can employ during remand? This is sometimes not an area that criminal lawyers pay much attention to. And I would therefore say that this is a stage where criminal lawyers can employ multiple strategies, which can subsequently work to the advantage of the accused later on during trial. Firstly, every remand application moved by the police must be opposed, in writing preferably. Always remember, the law is that when you oppose a remand, and if further remand is not granted, the consequence is that the accused will be released on bail. So there must be a robust opposition to every demand for extension of remand. And this must, as I say, be as far as possible in writing. You should have conversations with the accused persons during this time. And if the accused informs you that certain documents have been, that he's been made to sign certain documents under duress, put that on record while you're opposing remand. This may not be material at that stage, but it will be certainly material when you cross-examine witnesses subsequently. If an accused has been asked to give his handwriting or to give his voice recording, and he had some objections to the processes employed, again, make sure that those objections are brought on record while you're opposing remand. If confessional statements are obtained from accused persons under duress and you're informed of the same, you must immediately bring this to the notice of the court at the time when he is produced and a remand application seeking further extension is moved. This becomes relevant because during the stage of investigation, although confessional statements are inadmissible in evidence, the police relies very heavily on confessional statements. And if you are able to put your opposition to it, and if you're able to get it recorded in an opposition to a remand application that these statements have been obtained under duress, then it will help you to counter the narrative of the police during this stage of investigation. Very often, and I say this with the absolute sense of responsibility, we hear tales of custodial torture from our clients. We are now we now have the very unfortunate case that took place in Tuticorin in Tamil Nadu, where two innocent men were brutalized and they ultimately succumbed to injuries in police custody. Custodial torture is something that we should never, ever take lightly. We must always bring this to the notice of the court so that the court can either order an inquiry, the court can record the fact that the accused has been tortured. Sometimes there is enough evidence to suggest that the accused has been tortured. The court can order an independent medical inquiry. Again, this must be done immediately at the time when the news of the torture comes, before it is too late. You are talking about saving the life of an individual, and therefore very close attention has to be given to this aspect. At the time when I was a very, very junior lawyer and I was interacting with accused persons, I no longer can do that because of my designation. One of the first questions I would ask the accused when I met the accused in custody is whether he or she was subjected to any form of torture. This is an important question to ask, and if there is evidence to suggest that the accused was subjected to torture, it must be put in writing and there must be robust follow-up of what has happened to your client. Again, there are many other strategies that you can employ during remand. Whenever an application for remand is moved, you must insist that case diaries be produced, examined by the magistrate, and that the magistrate signs the case diaries till the date of production. Indeed, many rules and orders of different high courts mandate that the magistrate examines case diaries and, in fact, initials the case diaries so that there is no scope for further interpolation or fabrication at a subsequent date. This is a protection given to accused persons under law, and therefore, every defense counsel must insist that the magistrate examines case diaries, monitor the investigation that has taken place up until the date, and verify facts that is being said to the magistrate at the time of remand, and the magistrate initials every page of the case diary. It is a very, very important protection, and every defense lawyer must be cognizant of this fact. The other area which sometimes comes up during investigation is when an accused is put up before for test identification. Now, in 2005, an amendment was introduced which came into effect in 2006, whereby Section 54A was introduced in the code, which allows for an accused person to be put through a test identification parade where he can be picked up and identified, particularly in crimes where there is eyewitness account and the eyewitnesses are not known to the accused persons. Earlier, prior to 2005, the prosecution would only rely on Section 9 of the Indian Evidence Act for purposes of conducting TIPs, but now with the introduction of 54A, this procedure has been somewhat formalized. Now, while TIPs fall within the domain of investigation and the accused can refuse to participate in test identification parades, yet I would submit that the refusal must be accompanied by valid grounds. Let me take you back to a case which I did some years ago with respect to a client who ultimately got acquitted almost 12 years after his original detention. He remained in custody for 12 years. He was sought to be subjected to a test identification parade by the police at a time when he was not even legally represented by any of us as counsels. He was without legal representation. And yet, the response that he formulated was a response that came to such good use for us during trial. And it was a response which the trial court noted while acquitting him 12 years later. And what was his response? His response was very simple and basic, and something that most accused persons go through while in detention, and particularly police detention. His response was, I was shown to witnesses while I was in police custody. But he went a step further and he attempted to describe the physical appearance of one particular person who was repeatedly shown to him and was later on one of the prime eyewitnesses, so-called eyewitnesses in the case. The description was so accurate that when this witness, who was otherwise protected under the Witness Protection Program, came before court, we were able to see the accuracy of the description given by our client at the time when he refused test identification parade. And so what I'm trying to emphasize here is a client may well refuse to participate in the TIP. It can be used against you as a circumstance, though there is law to the contrary. But while refusing, if you can nuance the refusal by stating why are you refusing, in today's age where the arrest is followed by a press conference, sometimes the photographs of accused persons are published in newspapers and magazines and are flashed across television screens, you can very easily plead prejudice and say you have been shown to the world at large. Additionally, as had happened to my client so many years ago, if the client is able to give some description of the person who was repeatedly shown to him, it will make his refusal credible. It will help his counsels pick on that at later stages of the trial. What am I emphasizing here? A bold refusal is not good enough. But if it is accompanied by certain details which you can bring out through your conversation with your client, and if you can put that in your refusal application, in your refusal to the TIP application, it will make it simpler for you and easier for you at a later stage of the trial, when you're finally arguing the matter, to say that there were justiciable grounds for refusal. So always remember that if you can accompany something with evidence of obviously an accused cannot give evidence, but which will highlight, or which will help the court understand why that refusal was justified, then it makes your position much, much stronger. Treat TIP applications with care, and always insist that if you're refusing a TIP, that you accompany it with reasons. And those reasons must be of such a nature that you can pick on those reasons at later points in time during trial, at the time when you're cross-examining important eyewitnesses, including the investigating officer, at the time when you're cross-examining the so-called witness who sought to identify you in a TIP lineup. That refusal can be then put, accompanied with reasons, can be then put to the witness, and it makes your defense that much stronger. Another strategy which can be employed during investigation is the use of Section 156(3) of the Code of Criminal Procedure. Now, traditionally, lawyers look at 156(3) only from the point of view of a complainant. That is, when you want to initiate action against an accused person. But the Supreme Court in Sakiri Vasu's case and many other cases has said that the magistrate can monitor proceedings under Section 156(3). So even an accused can make use of this provision for purposes of monitoring. If the accused has a counter story to tell, which is contrary to the story which is put forward by the investigating agency, then please employ 156(3) for purposes of giving that counter narrative. Of course, you will be asking for a registration of a cross case, which is different from the case that is being investigated against you. But that material, if it is put out, and if you have sufficient material which will justify the invocation of Section 156(3), that is another strategy that you can employ during investigation. In cases where an accused has a credible counter narrative, which is going against the narrative of the investigating agency, 156(3) can come to your aid when you file a petition and ask for a registration of a cross case. So in the very first instance, you are able to put forward a counter narrative, and this will greatly help you as you move forward while you're doing the trial of this case. Likewise, if a case ends in a closure report, as you know, the law is very clear on this. Notice must be given to the complainant or the first informant, who can file a protest petition against the closure report. Sometimes the first informant is also a prospective accused person. Sometimes the first informant has also been investigated against. And therefore, as it had happened in the Talwar case, we felt it necessary to file a protest petition protesting against the findings of the CBI. So this too can be used, depending on the facts and circumstances of the case, to further your defense as a tool or a strategy during the journey of the case. Further investigation. Now, the law on this subject was somewhat ambivalent, but the Supreme Court In Vinubai Haribai Malviya and others versus State of Gujarat, a judgment that Justice Nariman, a bench headed by Justice Nariman, gave in October 2019, has held that even after the submission of a charge sheet, further investigation can be ordered. And the Supreme Court has gone as far as saying that even at the instance of the accused, further investigation can be ordered. And that right remains till the stage of charge. So if the investigative report has not investigated material aspects of the case which the accused feels is material for his defense, or to understand the case in totality, then an application can be moved in terms of this judgment for further investigation. And this judgment permits accused persons to move this application even after the filing of the charge sheet. So these are again strategies that you can employ for purposes of highlighting your defense and ensuring that a fair investigation takes place and that your client is not subjected to unnecessary suffering. The parallel strategies that you can employ during the stage of investigation is, of course, moving petitions in the High Court for quashing of the FIR. As you know, the parent or the law is on the subject is very clear. In Bhajanlal versus State of Haryana, 1992 AIR Supreme Court 604, a category of categories were laid out for purposes of quashing of the FIR. And essentially what the Supreme Court said was that where the uncontroverted allegations made in the FIR or the complaint or the evidence collected in support of the same do not disclose the commission of any offense and no case is made out against the accused, then the court must quash the FIR. This was one among many other categories that the Supreme Court laid out. So if you feel that the FIR does not disclose the commission of an offense, or at least a cognizable offense, and if you feel that there is no material supporting that allegation, then certainly an intervention in the High Court is justified, and you can either move a writ petition or a 482 petition asking for quashing of the FIR. Of course, this must be done with circumspection and care, because sometimes while moving these petitions, you may get an order which could complicate things more, complicate the case more against you. And we often advise clients not to move such a petition because we do not want to invite an order against us, even though we know that the case is largely without merit. So you really have to take a judgment call whether an application under 482 or a writ petition needs to be moved for purposes of quashing of the FIR based on the facts and circumstances of the case. In a case where there is absolutely no credible allegation against your client, this can be employed as a strategy. In a case which is a mixed, where there are mixed questions of fact, which might require a further evidence, or the court saying that this is a matter of trial, I would rather you not move the application for quashing of the FIR. Another area where you can employ strategies is when you find that the police is registering FIRs against your client on the same cause of action. There can be no second FIR, consequently no fresh investigation on receipt of every subsequent information in respect of the same cognizable offense or the same occurrence or incident giving rise to one or more cognizable offenses. This was made clear by the Supreme Court in T.T. Anthony versus State of Kerala, 2001, Volume 6, SCC 18, and paragraphs 19 and 20 and 27 of that judgment must be carefully read, where the Supreme Court says that the sweeping power of investigation does not warrant subjecting a citizen each time to a fresh investigation by the police in respect of the same incident giving rise to one or more cognizable offenses subsequent upon filing of successive FIRs. So the Supreme Court said that there is no scope for a second FIR if there is no, if the offense is the same and if the incident is the same, then every subsequent information pertaining to that incident will not warrant the registration of a first FIR or of a subsequent FIR. So this is again something which needs to be carefully examined. However, the counter view is that it doesn't cover cross cases. So where an FIR has been registered against you on one incident, you have every right to file a cross FIR against the complainant party. And the rule in TT Anthony will not apply to cross cases. Therefore, the incident may be the same, but where there are two versions of the same incident, the version of the complainant and the version of the accused, both sides are entitled to get FIRs registered based on different versions. That is the basic fundamental rule of cross cases. And this has been covered, this has been adequately explained by the Supreme Court in several judgments, including Babu Bhai versus State of Gujarat, 2010, volume 12, SCC page 254, and Upkar Singh versus Ved Prakash and others, 2004, volume 13, SCC 292. So while an accused person cannot be subjected to successive FIRs on the same incident, and nothing stops an accused person from filing a cross FIR against the complainant where he gives a different version. And such an FIR is not barred under law. These are some of the strategies that you can employ during the stage of investigation. I would go further and say, employ or use Section 91 to your advantage, even during the stage of investigation. 91 can be used during investigation, post-investigation. So if you need to summon material which you feel will otherwise be destroyed, please employ Section 91 and ask the court to summon such material. The only caveat as far as Section 91 is concerned is that you have to convince the court on the relevance of the material. And if the court feels that the material is relevant, then the court will invoke Section 91 and summon the said material. So with respect to call data, records, CDRs, which will determine locations of an accused person, etc., or any other evidence which is fundamental and material to the case. Even during investigation, you can move applications under 91 for the summoning of such material so that it is preserved and not destroyed. At the stage of trial, at the stage when the case goes up, the charge sheet is filed, the accused is summoned. One of the most important sections, which is largely ignored, is Section 207, the stage of supply of copies. Why do I say this stage is very important? This stage is important because this is the first stage during the life of the case when the accused person legally gets possession of the charge sheet, all statements of witnesses, and documents that the prosecution intends to rely upon and use against him or her. This is an important stage, and I cannot highlight its importance enough. So when you are seeking, when the case is fixed for scrutiny of documents, please take care with respect to the application you move. And I say this because very often, and particularly in voluminous cases involving financial crimes, where the prosecution relies on hundreds and hundreds of documents and statements, I find that the level of care employed very often is not enough. Why am I saying this? The prosecution may rely on materials which may be embedded in seizure memos. The seizure memos may say that the prosecution has seized various documents from different agencies or different witnesses. But the prosecution has given you a copy of the seizure memo, but has not given you the documents mentioned and seized in that seizure memo. It is important that you ask for those documents, because if the prosecution is relying on the seizure memo, then all documents embedded in the seizure memo must be given to an accused person. Therefore, the stage of 207 is a very, very important stage. And you mustn't just look at it from the point of view of the number of pages you have been given, on whether the documents are legible or not, or whether certain documents have just not been given to you. You must go further and examine every statement of witnesses and every seizure memo, which is part of the record, and see whether the witness is relying upon some documents which has not been supplied to you. You must ask for it, because when it is your turn to cross-examine that witness and the witness is speaking of that document, you don't have that document before you. So this applies largely in cases of financial transactions where witnesses talk about several documents, but those documents are neither part of the list of documents that the prosecution is relying upon, nor has it been supplied to you. So statements of witnesses must be read carefully, seizure memos must be examined carefully, and then alone should you move an application under 207. All of this constitutes deficient copies, and you must ask for it. It is your right, and it will be given to you. In fact, the Supreme Court has completely expanded the scope of 207 into landmark judgments. One is Siddharth Vashisht versus State, 2010, Volume 6, SCC 1, and the other is Shashikala versus State, 2012, Volume 9, SCC, page 771, in which the Supreme Court has essentially said that the right of an accused to obtain documents relied upon by the prosecution emanates from the constitutional mandate of following due process, including a fair trial, under Article 21. In other words, the prosecution is under a constitutional obligation to make a fair disclosure, not just of documents relied upon, but also of documents not relied upon, but relevant in arriving at the truth. Now, the use of the word fair disclosure is very, very relevant, because traditionally, our law has always been that we do not expect fair disclosure from the prosecution. It is their right to rely upon certain witnesses and to rely upon certain documents. If they choose not to rely upon certain witnesses or certain documents, again, that has been treated as an unfettered right of the prosecution. This is the first time when the Supreme Court deviated from that general principle and introduced concepts of fair disclosure, where the prosecution has collected but failed to produce before the court materials that may ultimately go a long way in proving the innocence of the accused. And Siddharth Vashisht was the first case where the Supreme Court said that if that has happened, the accused is entitled to copies of the same. Likewise, in Shashikala versus State, the Supreme Court said that let's not get entangled with the stage of making the request. The efflux of time that has occurred or the prior conduct of the accused is not material. What is of significance is if in a given situation, the accused comes to court contending that some papers forwarded to the court by the investigating agency has not been exhibited by the prosecution as the same favors the accused, the court must concede the right to the accused to have access to the said documents if so claimed. Such a plea must be answered at the earliest and certainly before the conclusion of trial, even though it may be raised by the accused belatedly. Now, in a recent judgment, which I think was pronounced just a couple of days ago, Arjun Pandit Rao Kotar versus State judgment on Section 65B. Although the judgment is with respect to Section 65B, the stage of 207 has been discussed in this judgment. And once again, the court has come to the conclusion that all documents relied upon by the prosecution must be given. So let me read out a portion of this judgment which came out 3 days ago. This is the portion authored by Justice Nariman, where it is said that Section 207 of the CRPC is mandatory. Electronic evidence, that is computer output, has to be furnished as soon as the trial begins. The reason is not far to seek. This gives the accused a fair chance to prepare and defend the charges leveled against him during the trial. The general principle in criminal proceedings, therefore, is to supply to the accused all documents that the prosecution seeks to rely upon before the commencement of the trial. The requirement of such full disclosure is an extremely valuable right and an essential feature of the right to a fair trial, as it enables the accused to prepare for the trial before its commencement. The judgment goes on to make another interesting observation. In a criminal trial, it is assumed that the investigation is completed and the prosecution has, as such, concretized its case against an accused before commencement of the trial. It is further settled law that the prosecution ought not be allowed to fill up any lacuna during a trial. As recognized by this court in Central Bureau of Investigation versus R.S. Pai, the only exception to this general rule is if the prosecution has mistakenly not filed a document. The said document can be allowed to be placed on record. Therefore, in terms of general procedure, the prosecution is obligated to supply all documents on which reliance may be placed to an accused before commencement of trial. Thus, the exercise of power by courts in criminal trials in permitting evidence to be filed at a later stage should not be allowed, as it may result in serious or irreversible prejudices to an accused person. I thought it relevant to refer to this portion of this recent judgment, almost brand new judgment of the Supreme Court. They were referring to the 65B certificate, but certain important points have been made in the portion authored by Justice Nariman, where he says that, again, reiterates the principle of fair and full disclosure at the start of the trial. And the other important point which has been alluded to is that once a charge sheet has been filed, it must be treated as if the case against the accused has been concretized. Now, I find this interesting because the invocation of Section 173(8) by the prosecuting agencies against the accused has now become so routine and normal that nobody ever blinks and asks, what is this additional material that you're seeking to produce? This was material you had or had access to during investigation, but you were not able to put it together and place it with the original charge sheet. And they continue doing it, sometimes till the very last stage. Now, Justice Nariman's observation seems to suggest that we can perhaps now employ strategies where we oppose the submission of 173(8) reports, supplementary charge sheet reports, with respect to materials that were in the possession of the police at the time when they produced or filed the original charge sheet. Strictly speaking, 173(8) relates to fresh material and not material which was in existence at the time when the original charge sheet was filed. Of course, if the police stumbles upon new material which was not in its possession at the time when the accused was charge sheeted in the first instance, they have every right to file a supplementary charge sheet. But by and large, I would use this phrase that Justice Nariman used, the case against the accused having been concretized at the time of the filing of the principal charge sheet. Therefore, unless the prosecution can prove inadvertence, mistakenly we didn't file this document, although we made reference to it, they should not be given an opportunity to keep on filing supplementary charge sheets. That goes against the letter and spirit of Section 173(8) itself. So coming back to 207, a very, very valuable stage. a stage where many, many rights are available to an accused person. It must be strategized in a way where you seek every ounce of information that the prosecution has in its possession, that it is concealed, that it has not revealed, or it has revealed partially. This is in the spirit of fair disclosure, which has been alluded to in Siddharth Vashish's case. The next stage at which strategies can be employed is at the stage of framing of charge. Now, again, the Code of Criminal Procedure has makes reference to different kinds of prosecutions. You have the summons case prosecution, where a notice is framed under 251. If you were to read the language of Section 251, it actually says that not just whether you plead not guilty, but whether you have a defense to make. And I would suggest if you have a concretized defense in mind, then you must put forward that defense at the stage of the 251 notice. In fact, courts demand it in cases prosecuted under Section 138 of the Negotiable Instruments Act. I've extended it even with respect to criminal defamation cases, because those are also summons triable. Where you're pleading a defense, put it out in your 251 notice if it is a summons case procedure. This is important because it ties up with the defense, the same defense you're taking subsequently, and you will be able to tell the court that you have been consistent in the manner in which you have pleaded your defense. In a sessions triable case, the charges are framed under 228, but under 227, you have every right to contest the case of the prosecution. You may do so in writing, additionally, of course, to oral arguments. And the law is that even at this stage, if two views are possible, the view favoring the accused must be taken. The court should not act as a mouthpiece of the prosecution. The court must, for the limited purpose of finding out whether a prima facie case is made out or not, the court is entitled to sift evidence. And if the court feels that there is some suspicion, but not grave suspicion, the court will be well within its rights to discharge the accused. So you can nuance your strategy around this case by pleading two views, by pleading that the standard has not crossed the threshold of suspicion, and that you cannot come to the conclusion that there is grave suspicion against the accused. With respect to trials of warrant cases on a police report, 239 is the provision which is to be used for purposes of discharge. With respect of trial of warrant cases instituted not on a police report, then 245 is the section for to be employed for purposes of discharge. Now, I'd like to read section 245 because it's a slight deviation from the other sections. And 245.1 says that if upon taking all the evidence referred to in section 244, the magistrate considers for reasons to be recorded that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. So there is a very interesting shift in the language used in 245.1. This is with respect to warrant cases not instituted on a police report, where the court has the advantage of pre-charge evidence. The language used is that if upon consideration of all the evidence recorded in the case, the magistrate comes to the conclusion that no case against the accused has been made out, which if unrebutted would warrant his conviction, the magistrate shall discharge him. So that's an interesting deviation and should be borne in mind while dealing with cases, warrant cases not instituted on a police report. Now, what if charges are framed against you? Again, a fairly important engagement happens between the client and the lawyer at this stage. Charges are framed. What should we do next? Should we straight away go to trial, or should we challenge the order in a superior court. If the charge is framed by a magistrate, then obviously the court of preference would be a sessions court, in which case you employ section 397 of the code, that is the powers of revision, or you go straight up to the High Court, either under 397 or employing section 482 of the Code of Criminal Procedure. But strategically, what is the advice you give to clients at this stage? Should we move? Should we not move? I think the thumb rule here is, if the order is of a nature which is completely unsustainable on evidence, certainly move. You must move, either under 397 or under 482. Choose your forum depending upon the section you are invoking. If, however, you feel your case will be worsened if you go to a superior court, and if findings come from a superior court, which you'll have difficulty dealing with during trial, then it's best not to challenge the order. Really, it depends upon the facts and circumstances of a case, but this is again a strategy that you can employ, either filing a revision against charge, or in a given case, if you want to rely upon certain unimpeachable evidence which is not placed by the investigating agency before court, you can employ section 482, because under that section, the law says that if the evidence is of an unimpeachable character, the court can go beyond the charge sheet and look at it. What is the difference between 397 and 482 is again something which is engaged lawyers. Essentially, where you're challenging the correctness, legality, propriety of any finding, sentence, or order, you move under 397. There are certain embargoes placed under 397.2 and 397.3. 397.2 prevents you from challenging an order which is interlocutory in nature, and 397.3 prevents you from moving a second revision petition. 482, of course, is the inherent powers of the High Court. It is a power which I believe no court in India has, not even the Supreme Court of India, because under the inherent powers of the High Court can exercise powers to give effect to any order under the court, to prevent the abuse of the process of any court, or otherwise to secure the ends of justice. 482 can be employed at for various reasons, not necessarily a challenge to charge. You can challenge a summoning order under section 482, or multiple other orders which are passed by the trial court at different stages. But with respect specifically to charge, the decision whether to employ 397 or 482 would largely depend on whether you have materials outside the scope of the charge sheet, which is of an unimpeachable nature, which the High Court can look into under section 482, but which typically cannot be examined under 397, because 397, the jurisdiction is limited only to challenging the legality, propriety, or correctness of a finding or a sentence or order. So this is again a very interesting stage where you decide to employ a strategy of challenging the order on charge, either to the immediately superior court or going straight to the High Court, depending on the facts and circumstances of the case, and there can be no one view on the subject. Suppose you decide not to go up, you decide not to challenge the order on charge, or your challenge has been dismissed, you of course go to the stage of evidence. And this is perhaps the most important stage in the life of a criminal case. The entire gamut of evidence produced by the prosecution can be tested by the accused in various ways. And so it is important to remember that preparation for this stage is of utmost importance. If you're dealing with an offense against the human body, say a murder case or a case where a physical incident has taken place, I always insist that spot inspections be done, that you examine when the incident took place. Was there sufficient light? Was it possible for the eyewitness to have seen the incident as he claims that he that he did? Were there any other restrictions of sight, or were there any other restrictions by virtue of which he could not have seen the incident in the manner in which he said he saw the incident? All of this is part of the preparation for this one big stage of the criminal case. As you know, evidence includes examination in chief, cross-examination, and re-examination. And as much care and attention must be given by defense counsels to examination in chief as they give to cross-examination. Because during examination in chief, at various points in time, the prosecution will try and introduce evidence which is either inadmissible, and therefore you need to make the objections at the right time. What I'm trying to emphasize is, as important cross-examination is, examination in chief is as important. And the objections that you need to take, objections to hearsay evidence, objections to admissibility of electronic evidence, objections with respect to disclosure statements and how they're inadmissible in evidence, objections with respect to exhibition of certain documents, etc. All of this needs to be robustly taken at the stage of examination in chief. And whether or not the objection is decided at that stage, and the law seems to suggest that it will be decided at a subsequent stage, the objections must form part of the record. As I said, objections to hearsay, Section 60 of the Evidence Act, objections to mode of proof, particularly with respect to documentary evidence, objections with respect to the admissibility of documentary evidence, the objections with respect to 65B certifications, objections with respect to the marking or exhibiting of documents, competency of witnesses, leading questions, Sections 141 to 143 of the Evidence Act. All of this needs to be taken at this stage. Again, if a witness is giving an opinion, you have to take an objection unless, of course, the witness is an expert witness. The statement under Section 161 is not substantive evidence, and any attempt made to exhibit the statement, unless, of course, the witness has been declared hostile and the prosecutor is confronting the witness with the statement, must be scrupulously opposed. As I said, disclosure statements per se are inadmissible in evidence, and an objection to their admissibility must be made. Coming to the scope and structure of cross-examination, I'm a great believer of cross-examination being structured. With cases now being complex, we are dealing with complex financial transactions, complex trails of evidence, even with respect to offenses against the human body. Large the prosecution now seems to rely on more and more evidence. And therefore, much as I admired them, the cross-examiners of the past who would just go there and spontaneously conduct a cross-examination, perhaps that's not possible now, given the voluminous nature of cases that most of us are dealing with. And therefore, a structure of the cross-examination must always be prepared before you go into court. I look at the 161 statements. I look at what is sought to be established through those 161 statements. I look at the documents that the witness who is being presented in court the next day is seeking to exhibit, and what is sought to be established through the exhibition of those documents. And I structure my questions accordingly. I would suggest during this phase where you are preparing for cross-examination, you must have intensive interactions with your client. Never forget, it is your client's story that you're putting out in court. It's not like any of us knew what happened during the incident. It is essentially the client's story which we are putting out in court. And you would be surprised how much the client will be able to contribute to these discussions and to the ultimate formulation of questions, if only you sit with them and discuss with them what really happened and how the witness needs to be attacked in court the next day. By attack, I certainly don't mean physical attack, but attack through lawful cross-examination. With the kind of material which exists today on social media, on the internet, it is also extremely important if possible, to do background checks of witnesses, to look at whether the witness has testified before, whether there's something incriminating about the witness's past, because not only can you question a witness with respect to the evidence against your client, but anything which impeaches his credibility is also admissible in evidence. And therefore, you can ask those questions. Sections 146 and 155 of the Indian Evidence Act permits you to do so. I would also encourage you to put forward your defense before material witnesses. If you don't want to ask direct questions, you can nuance it and formulate it in suggestive ways. But if you have a defense, don't wait till you produce defense evidence or give a statement under 313. That defense must consistently come out during the cross-examination of material witnesses, witnesses who are material to that defense. You must bring it out. So if your defense is one of alibi, or if your defense is one of false implication, and you have reasons for that false implication, put it out from the beginning. Don't make your cross-examination or the statement or the evidence look jerky and casual. It should be consistent. And I say this often, and it's probably difficult to imagine that cross-examination can be graceful, but there should be a certain grace in the way you cross-examine. The cross-examination must not be jerky. One must follow the other. And so whichever court is reading your final evidence, gets a sense of what you were seeking to ask and why you were seeking to ask certain things at certain points in time. So bringing in your defense is also very important. The value of suggestions can never be underplayed, even if in a particular case you are not able to confront the witness with his previous statement, or you're not able to attack his credibility, or you're not able to bring something which will refute the nature of evidence which he has given. It is still important for you to refute the gravamen of the allegations that he's making by formulating appropriate suggestions and bringing those suggestions on record which refute the case of the prosecution. I cannot emphasize enough about the value of suggestions. Suggestions must be given, and particularly with respect to every incriminating aspect that the witness has stated against you. Of course, with respect to sexual offenses, there are certain embargoes, and those embargoes are provided for in Section 53A, 114A, 146, where certain questions relating to the past sexual history of the prosecutrix cannot be asked, and therefore we must, as officers of the law, take note of those embargoes and cross-examine accordingly. Another strategy which can be employed is the use of Section 311. In a long trial, there will always be oversight. When you have 200, 300 witnesses, something will be left behind. And while the prosecution seems to use 311 quite frequently and at the drop of a hat, as defense lawyers, I'm not saying we should overuse 311, but if certain things have been left out due to inadvertence, you must move 311 for purposes of recalling the witness and confronting the witness with whatever you have not been able to confront him or her with in the first instance. You can use 311 also for other purposes by asking the court to summon any witness. So it doesn't matter whether the witness has appeared in court or not, but an application can be moved if you feel that a particular witness was examined by the prosecution but has not been produced, or if you're able to convince the court that that witness's testimony is important for the just decision of the case, then the invocation of Section 311 is very, very crucial to the end result of the case. And the law on the subject is clear. It should not be used to fill up lacunae in the language of the Supreme Court. But by and large, if there is some inadvertence, most courts do allow you some opportunities by recalling witnesses. At the appellate stage, the use of Section 391 is again a tool that needs to be exercised, both by the prosecution and by the accused. Additional evidence is permissible at the appellate stage in exceptional circumstances. It is a power which is used sparingly, but courts have used it in order to arrive at a just decision. The Delhi High Court in the Hashimpura case, Zulfikar Nasir versus State of Uttar Pradesh, did invoke Section 391 when it found that a material piece of evidence had not been exhibited during trial. They sent the case back to the Sessions Court for the collection of that evidence and the recording of that evidence. And then the case file was brought back to the High Court. So Section 391 is another strategy that can be used in appropriate cases. Section 313. Again, we tend to look at this casually sometimes, but 313 is so important in the journey of a criminal case. And why do I say so? I say so because this section, we tend to look at this section simply to say incorrect to almost all the answers, all the questions that are asked of an accused person. But you can use this section more creatively by giving answers which are in line with your general defense, by repeating what the defense you've taken and putting it out in no uncertain terms that the case of the prosecution is not, has not been fully established. In fact, the parallel defense that you have taken throughout the trial must be considered. So 313 is an opportunity, and it's an important opportunity that you should never let go of, because it gives you the chance to get your client to make a statement to refute the averments or the allegations that is being put to you. And because it's not a statement under oath, the risk is very, very little. So employ 313 more creatively is what I would say, and put forward your defense in the most robust manner possible. Courts now even permit accused persons to give written statements in addition to the answers they have given under Section 313. 313 2 makes it clear that no oath will be administered. 313.3 makes it clear that the accused shall not render himself liable to punishment. And 313.4 says that the answers given by an accused can be taken into consideration for purposes of determining the final outcome of the case. I am saying use it positively in your favor instead of simply giving incorrect, it is wrong kind of answers. Creatively use it in a way that you put forward your defense in a robust manner. As you know, 3135, which is a latest amendment to the section, enables both the defense counsel and the prosecutor to collaborate in this exercise of making questions. Even that is something that you can do, where you can look at questions carefully. And traditionally, at least at the time when I had begun practice, the prosecutor would ask questions, and sometimes those questions had the prosecutor, rather the court, would put forward questions, and sometimes those questions would have no bearing on the evidence of the case. This, with the introduction of 3135, if something has not been proved, the defense counsel can lawfully say, this question cannot be asked of my client. Of course, the iconic judgments under 313 is the judgment of the Supreme Court in Sharad Bidhi Chand Sarda versus State of Maharashtra, 1984, Volume 4, SCC, page 116, where every aspect of a criminal case has been dealt with, including Section 313. At the appellate stage, by and large, the law has been that if a particular circumstance has not, or incriminating circumstance has not been put to the accused, so that the accused did not have an opportunity to explain it, then the advantage of that must go to the accused. That law has somewhat been compromised with now, with more and more courts, appellate courts, asking the additional questions at the appellate stage. However, you can still make a jab at it and plead prejudice if a particular circumstance of importance has not been put to you. And reliance has been made off that circumstance. You can say, since I didn't get an opportunity to respond, therefore this circumstance must be eschewed from consideration. 315, again, rarely used as a strategy by criminal lawyers, largely because by putting the accused up on the stand as a defense witness, you are exposing the accused to cross-examination by the opposite side. And you're not entirely sure whether that would turn out to be a meaningful exercise or not. It should be employed where the accused has taken one of the exceptions, either one of the general exceptions or exceptions within certain categories of offenses. For example, under Section 499, there are a list of exceptions. If you pleaded truth as a defense, then it may be in your interest, if you feel your client is up to facing cross-examination, to put up the accused as a witness in his or her own case. This is again a strategy which will depend upon the facts and circumstances of the case, and if you have the confidence that your client will in no way harm the interests of the case, you can employ 315. If, on the other hand, you feel that the case of the prosecution as it stands has not been proved and there is no need to put up your client as a defense witness, you may ignore the stage. There are, at the start of this address, I had said that there are certain residual strategies which are rarely used by lawyers, which I'd like to highlight. Section 91 can be used, as I said, at any stage of the trial. It is interlinked very closely to Section 294, admission and denial. And I'll say how. So suppose, as an accused person, you've moved an application under 91 asking for the submission of some material before the court, and the court has agreed to submit that material, to bring that material, or to allow that material to be brought before it. It's still not been proved. Now, you can ask, just like the prosecution asks the accused to admit and deny to documents, you can put forth that material or any other material, including materials that have come out in parallel civil proceedings. You can ask the prosecution to admit or deny to those materials. So even the defense can creatively employ Section 294 to its advantage in some cases. Likewise, there is Section 310, which relates to local inspection, where you can convince a court to conduct a local inspection of the premises, the spot of occurrence, which will help the court decide whether the incident took place in the manner in which it took place. Again, you must be very careful. You must be sure about what you are going in for. If you feel that such an inspection will help your client, then please employ Section 310 of the Code of Criminal Procedure. Let me give you an example. In a case under the Prevention of Corruption Act, the prosecution's case was that the accused person had taken a loan without fulfilling certain mandatory requirements of the grant of loan. One of that was that the accused should have hypothecated stocks that were in his possession to the bank, which it did not do so. It was the case of the defense. In fact, I was the defense counsel. It was a case of the defense that right from the start, there was a go down, which was mortgaged to the bank. And in the go down, there were stocks of which matched the description of stocks given in the loan application, over which the bank had put its seal. The CBI, in its criminal prosecution, chose to ignore that evidence. During or towards the end of that trial, the civil proceedings against the accused ended in DRT, with the accused entering into a compromise with the bank and repaying the entire loan amount with interest. But in the final order that the DRT gave, closing the case, the DRT, on an application moved by the accused, a defendant in that case, passed an order that the bank remove its lock and key from the go down, which had been hypothecated to it, and release all the stocks inside that go down back to the accused. This was documented in the final order of the DRT. I placed the order and many other such documents, including documents of the bank saying, we are now removing our lock and key, you are welcome to take back your stocks, etc., and the inventory they had made in this regard. I placed it for admission and denial, and the prosecution predictably said, we neither admit nor deny. Having exercised that stage, I then moved an application under Section 310, asking the court to do a physical inspection of the premises. And the court allowed that application and went and inspected the go down. Mercifully, up until that time, all the stocks had not been removed. It was still inside the go down. But there was evidence that we discovered of a lock of the CBI on the go down itself, which means the CBI was aware that there was a go down which had been hypothecated, which had the lock and key of the bank before the CBI chose to put its own lock and key, and inside there was evidence of all these stocks identically matching with the inventory given to the bank. And therefore the substratum of the case fell because the allegation of the prosecution was that loans were taken without following procedures of the loan. There was no hypothecation of any stocks. There was no hypothecation of any go down. We were able to prove otherwise, and coupled with the fact that the bank loan was repaid, although that alone is not a circumstance for purposes of securing an acquittal. We did secure an acquittal in that case based on some of these innovative tactics that we employed in the case. So these are the various strategies. I'll end by saying that ultimately the strength of the Constitution lies entirely in the determination of each citizen to defend it. If justice is not equal to all, it is not justice. Today, unfortunately, the idea of injustice has become institutionalized. We should aim to reestablish processes that demand accountability and not frustrate it. We must demand transparency in the manner in which investigations and prosecutions are conducted in this country. We should always remember that law without liberty will not bring order, but it will bring anarchy. Just to end, I'd like to quote from one of this country's greatest criminal lawyers, K.G. Kannabharan, who said that the law defines the offense, the state defines the offender. As criminal defense lawyers, we advocate those who cannot tell their stories, and we defend those whose freedoms are in peril. I'd like to add and end by saying we must never stop defending those who have no one else to defend them. Otherwise, democracy itself will be in danger. Thank you.
Thank you, ma'am. I don't think we have enough words to express our gratitude for what an enlightening lecture that was. I was actually going through all the questions and there have been many questions that the participants have posted. But as I was going through those questions, I realized that you have addressed most of them in your lecture, and you have answered them in detail, along with the case laws, along with the citations and the authorities held therein. Um, so I would restrict the questions that I've asked you uh, to themes or topics which you have addressed in your lecture, but probably there are different perspectives that have emerged that probably you can address. Before I go into the questions that our participants have posted, I have a personal question to ask you. Um, and that is that I've been witnessing when I cover the bail applications, and especially in the cases where offences under UAPA is involved. We see that technically the courts are not supposed to go into the merits of the case. While adjudicating bail, it's supposed to be prima facie balancing of interest. But these orders, time and again, have recorded the evidence produced by the prosecution uh, in detail while they record the order of the bail. And in most of the cases where the bail is denied, we see that the reasoning provided by the court is simply the copy paste of the evidence adduced by the prosecution. I think in very, very few cases, and I think this has become an exception. And one of the cases is the one you cited by the Justice Bhambani's judgment from Delhi High Court, where we actually get to see the idea that the police cannot simply quote the evidence, and the court can rely on it, that we have the CCTV footage, and we have the statement of the eyewitness, but the police has to link the evidence to their argument that this person was involved, and the linking of that needs to be rational and reasonable. For instance, that Justice Bambani went on to question that you're showing me the CCTV footage, but the CCTV footage doesn't show the accused. It's not clear. So I want to ask you that, time and again, we are seeing that this is a growing trend in bail matters. So how does a defense lawyer address this issue?
Unfortunately, what should have been an exception has been normalized in UAPA. And everything exceptional has now become routinized. So general law says maximum period of detention 90 days. UAPA says up to 180 days. We are now at a stage where that has become normalized. That it is no longer treated as an exception, which should be rarely exercised, but it is treated as normal in every case. Likewise, because of the restrictions with respect to the bail, to the grant of bail, which are inherent in the Act itself, where literally the court has to give a finding almost of innocence. It has to come to a determination that there is no prima facie case against an accused, which is an impossible thing for a court to do. Then why hold a trial if there is no prima facie case against the accused? It becomes very difficult for courts to judge these bail applications in an atmosphere which is devoid of this kind of surrounding noise. But actually, if those provisions were not there, most of these cases would collapse very easily and bails would be very easily granted, because the prosecution, at least in the cases that I am seeing, has just not been able to connect the dots, lay out the structure of their case in any coherent manner. Most of the time, the prosecution is giving a moral lecture. And which is why I think in that judgment, the court said, we are not looking at the moral aspect of any case. We are here to judge the evidence. And if the evidence adds up, then fine. If it doesn't add up, it has its consequences. Yes, you're absolutely right. The courts, while dismissing bail applications, cause grave prejudice to the accused, because they look at the evidence stacked against the accused, which is really parroting the version of the prosecuting agency, and they put it out as findings, whereas those are untested, and they still have a long journey to go. And sometimes I feel that they fail even on the anvil of common sense. So why is it being given this kind of importance? I think partly the reason is because of the structure of the act itself, which gives no room for leeway. But sooner rather than later, courts, with the increasing use of very draconian legislations like the UAPA, courts will have to ask a question: how much longer do we have to keep people in jail before we decide that these provisions are completely unconstitutional?
On that note, ma'am, I would like to ask you, do you think that, as you mentioned, that there are these draconian legislations that sort of provide an additional burden and pressure on courts when they're adjudicating bail matters in these cases? Ma'am, there are certain terms that are used, not just in the media discourse, but also to that fact in the arguments forwarded by the prosecution. And one of these terms is anti-national. And as we know that anti-national, the term does not find a place in the law books, and it is the term manufactured and sort of put and nowadays used quite frequently in cases involving draconian laws. I would like to ask you that as a as a criminal lawyer who's representing downtrodden and usually the disadvantaged persons who are targeted under these provisions, and they know that there's already a narrative prevailing both in the media and the pressure that has been built consequently on the judges. How does one tackle this narrative of that has been built, that is, such as anti-national and such as using loose words such as terror links? So how do you think that how does a criminal lawyer handle that burden, that additional burden of dispelling the pressure that is being created by terminologies that are not even part of the law? So how do you do?
Again, very valid question, and it places us in a very, very, very difficult position because it's not a level playing field. You see, at the end of the day, there are two parties to a litigation. In this case, in criminal cases, it's normally the prosecution versus the accused, and both of them should be treated equally. There should be a level playing field. Now we have completely changed the terms of engagement, where one party is given so much power and so much relaxation, whereas the other side is constantly being told things that it is not capable of refuting. Now, if somebody calls you terms like anti-national, how do you refute it? I don't know. I'm asking you, how do you refute it? I often say, criminal defense lawyers probably are the biggest patriots because we work in defense of the Constitution. We work for people who otherwise have no voices. We sometimes work for underprivileged people. So to use terminology which is not found in any statute, which has no statutory backing, which is just part of ordinary colloquial discourse, which has now become the predominant discourse, it's sad that this has entered the legal field. And there is no way in which one can refute it. Of course, at the end of a trial, when none of this adds up, you have more and more courts granting acquittals. But look at the price that the individual has paid, has been in custody for 10 years, 8 years, 12 years, without a day of sunshine, has been condemned as an anti-national, as a person who's worked against the country, as a person who has thoughts which are not in keeping with the national with some mainstream narratives. What is the point of that acquittal at the end of 12 years, when at the very beginning most courts understand that none of this will add up? So that is why I answered the first question in the way I did. I'm hoping that sooner rather than later, there is a pushback from courts. And courts tell us that, look, there is the realm of evidence when none of this matters. If you have a case where you can show some violence, some incitement to violence, some actual violence, we are willing to go ahead with the evidence you have. But if you're going into people's minds, and if you're going into what you think somebody should say or not say, or if you really, you're entering into very dangerous territory. And criminal law uh, is about evidence and proof, and you can't substitute it with imaginary offenses. And that is what this is all about. We are looking at imaginary offenses. We are looking to criminalize people because they don't think like us. That's fine. You needn't think like me. I needn't think like you. But I'm entitled to it because I am part of a robust democracy ruled by the rule of law. I am part of a constitutional democracy, which constitution protects me. And therefore, there is need, I think, for urgent judicial intervention to stop this kind of narrative, and also to look into some of these draconian provisions and ask the basic question: is this even valid? Is this even constitutional?
Ma'am, I would like to ask you as to how much time we have left here, because as I said,
you can go ahead.
When we, when we have a topic of discussion such as this, and we are actually talking about different themes, there are multiple questions that emerge. One of the questions that was asked during the session when you talked about custodial violence is that the question refers to as, what are the materials that a defense counsel can rely upon to prove custodial torture before the judge?
So yes, that's a very good, and this would require interventions on behalf of the defense counsel, because the minute you realize that there is physical injury, and sometimes it doesn't even have to be physical injury. Torture can be of many kinds, but certainly where there's physical injury, you must immediately move applications for the examination of the person before an independent board in an independent hospital. You must, you must start collecting jail records where if there is manifestation of injury, then that will get treated in jails. And you must place it before court spontaneously. Picking it up after several months or several years, you would have lost the moment. So it is important that you bring it to the notice of the court immediately. Now, as I said, custodial torture need not just be physical. It can be, you're made to stand in a room for 24 hours without moving. There are many kinds of torture. There are many kinds of, this must be placed. Now, it's strange, but once I was told by my instructing team that the client who I ultimately represented was diabetic, and he was made to eat rasgullas. Now, this is another form of torture, and he consequently had a seizure after that, which was again documented medically. Now, these are facts which must be placed before the court immediately. Create a record is what I tell all lawyers, all lawyers who come to me for advice. You must create a record. Without a record, arguing in the air will not lead you or your client's case anywhere. And so by creation of record, I mean move applications, move interventions, ask for relief. It doesn't matter whether it's accepted or not accepted, but you've created a record which suggests that something wrong has happened.
Yes, I think what I take from that is that it is also required for lawyers to understand what torture is, as you said, and understand different facets of torture, and not just only focus on physical torture, but how torture manifests itself differently. Ma'am, there's another question regarding section 207, where you ask, where the person asks is that what if it is recorded, the application is allowed, it is recorded in the order for the documents to be provided. What if the accused gets to know that he has not been provided with all the documents? That
supplementary applications.
Okay.
Till you are satisfied, and so there are. I actually find 207, the stage of 207, 313. These are very, I call them democratic sections in the CRPC. And why do I say it? Because it takes note of the satisfaction of the accused. I need this document as an accused person. You have given me part of it. You have still concealed the rest of it. I will move a supplementary application that the spirit of the order has not been complied with. The order said that the entire docket be handed over to me. Only part of it has been handed. So till my satisfaction is recorded, now it's up to you how much you can stretch that stage. But till your satisfaction is recorded, you should keep pushing for the entire set of documents to be given to you.
Ma'am, I think another thing that I think our participants can benefit from is that I think time and again you have mentioned that an assessment needs to be made by the lawyer as to whether it is the right stage to approach the superior court. You said under section 397, 482,
Yes.
whether I should move my bail application now, should I move it later? So I think it would be very beneficial for us to know that what sort, like how does one go about this, because I'm assuming that this is an extra textual analysis. I mean, no book can teach you how to make this assessment whether the going to superior court would be beneficial. So I think if you can share as to some of the things that can be looked at while making this assessment.
So Karan, I wish I could give you a comprehensive answer, because there is no comprehensive answer.
Yes.
The assessment is the assessment we make of the risk. So it's really a risk assessment. Sometimes you get the most bizarre order, and the order gives you so much more ammunition than you thought you would get, because it's so bizarre. And so you make use of that, and you move ahead, saying that this is unsustainable. From where are these findings coming? So it will also depend on the nature of order you get, and the nature of evidence that exists. Sometimes the order is unsustainable on facts because the evidence is contrary to what the order has recorded. Again, it's pretty easy and it doesn't require rocket science to know. Go ahead, move on. But sometimes in this 50-50 cases, you're not willing to take the risk because you feel that it could go either way. If you feel that the position of your client won't be worsened by going to a superior court, please go. But if you feel that any observations coming against your client could prejudice the client in trial, then I wouldn't go. So really, it's a risk assessment. It is an assessment about the nature of order, which I'm seeking to impugn. It is the assessment about the examination of evidence in that order and whether the court has gone far beyond the case of the prosecution. Also, if I have materials, which, as I said, which can only be looked into under Section 482, which the court, by reason of Devendra Nath Pardhi's judgment and other judgments, although that too has been relaxed now, the trial court has not considered such materials. For example, ROC documentation. I was not a director at the time when the offense was committed, or other statutory documentation, which is beyond proof. Maybe your passport, maybe, I don't know, different cases throw up different kinds of unimpeachable evidence. So if you have something like that, and the Supreme Court says the High Court can examine it under 482, then of course you must go. So if there are two aspects of it, one, on the plain facts of the case, if the order is unsustainable, and two, if you want to go beyond the order and place materials which the High Court can look into under its powers of 482, then we must go ahead.
Yeah. Also, I think, ma'am, what I gathered from your lecture is that you put a lot of emphasis on defense using every opportunity available to put forward the narrative as clearly as possible. And you talked about using Section 91 of CRPC, 207, 31C, where you said that if that opportunity is given to you, make sure that that you use that opportunity in putting out your narrative as clear and sound as possible. So, ma'am, one of the questions that was asked during the sessions, and actually there are two questions, I'm going to combine both of them.
Yes.
One is that what if, how do you deal with forensic evidence and expert evidence when it is produced before the court, and how do you sort of try to deal with that as a defense lawyer? And second is that how do you sustain that narrative? Because, trial can be very long.
from where it starts and all the multiple opportunities that you have to put forward. So how do you sort of ensure that the accused in their statements is maintaining and sustaining the narrative that you're trying to put forward? So these are the questions that also.
So I'll answer the second question first, about how to sustain the narrative. Very valid question, because as you know, in India, nothing ends within any reasonable time frame. And I have dealt with cases which have gone on for 12, 13, 14 years in the court of original jurisdiction. The important thing really is that the narrative should be sustained only if the lawyer is interested in that narrative. I don't think we have the right to disengage just because a case has gone on for 10 or 12 years, or we have the right to lose interest. And this is something that I will say and say again and again. We take on a responsibility, whether we are paid for it or whether it's pro bono. We've taken on a responsibility. We must finish the job. So it's possible that in a long trial, other factors intercede, but it is important for lawyers never to lose interest in a case and to take it to its logical conclusion. So no matter what, in the case where I said the man was acquitted after 12 years, I think the 313 was recorded in the 10th year. But not just me, there were other counsels who appeared in the case for different accused persons. Each one of us put forward a very robust 313 response by connecting the dots from the first witness onwards, and by re-examining and reassessing the evidence. In fact, I believe that the exercise for final arguments begins at the stage of 313, because you have an opportunity of marshalling the entire evidence, looking at details which you may have forgotten, or which would have slipped you. Oh, this also exists. I'd forgotten this exists. So you do that marshalling at the stage of 313, and then the stage of final arguments becomes simple. So really, 313 is a precursor to final arguments, and much of the job which you do for final arguments, at least the revision of the material, takes place at the stage of 313. Your earlier question was. You'd asked a question prior to this.
Yeah. So one of the questions was that, in certain instances, what happens is that, a prosecutor doesn't bring forward the expert witness to present the evidence, but you think that, having the expert witness being produced before the court would be beneficial to my case. So how do you sort of deal with that?
Yes, no, expert witnesses is a complicated area, and unfortunately, especially post-mortem doctors, forensic witnesses, and now with DNA playing such an important role in so many things. Traditionally, we are ill-equipped to deal with science, right? And therefore, no matter how many doctors you may have cross-examined in the past, or how much forensic evidence you looked at in the past, we somewhat have grappled over electronic evidence, and we're somewhat in tune with it. But things like DNA and DNA evidence, etc., requires very meticulous examination. I always say that if your client can afford it, and that's a big if, you must engage the services of a field expert for for purposes of understanding this evidence and for purposes of cross-examination. But again, it's done routinely abroad, but in India, because of paucity of funds and the fact that so many clients across the country are so poor, it's not possible to engage domain experts unless domain experts are willing to give their advice pro bono also. But that is one area where we should look into. I think a lot of research. I mean, I can talk of cases in Delhi from my office where we've had the advantage of domain experts leading us through the evidence and explaining what the evidence says and how it should be looked into, and therefore how it should be attacked. But it's probably very difficult for the entire gamut of cases in the country, because a large majority of people who face criminal prosecutions are poor.
There are, our question and answer portal or section, I don't know what that exactly is called, uh, is actually, it's been spamming with questions, if I should use that word. But due to paucity of time, I tried my best to address the questions which I thought were not uh, addressed during the lecture. But there are many questions that are raised on technical aspects, on various provisions of the CRPC that you actually talked about in your lecture, and you quoted judgment for, and I think those questions were very well answered during the lecture itself. Before we leave, ma'am, there is one question, last question that I would like to ask you is, it is not a secret that criminal litigation is a demanding calling. It's extremely taxing and requires discipline and perseverance. To all the young students, lawyers who will probably be the first generation lawyers in their families, lawyers from tribal communities, disadvantaged communities who want to represent and work for their communities. All these people who are listening to you today and who's privy to your work would like to know as to what they can do and what are the things that they can engage in keeping that perseverance and discipline intact, which requires in this demanding profession of criminal litigation.
I would say play by the rules. There's always a temptation to subvert the rules. I don't approve of it. I think it's counterproductive. Even if you think there's some merit in it in the short run, I think it's counterproductive. I would like to see the young generation of litigators who are coming, and I'm already seeing a large number of them in the city where I practice. I would like to see them go forward with a sense of commitment and duty. It's not just about making money, although I have no objections if people make money, we should make money. But it is also a larger duty we perform as criminal defense lawyers. And we must always be cognizant of the fact that people who walk through our doors, whether they are accused of a horrific crime or they're complaining about a horrific crime, have very dark stories to tell. And so we must be empathetic. We must never be judgmental. We must believe that our officers will give them the space to be to tell us their truths. Some of it will be very uncomfortable. Some of it will not be palatable. Some of it you would like to, you would wish you had never heard. But it is still important for us to uphold that sacred principle that every accused person, no matter what you think of that person, is entitled to a fair trial till the very end. And he's entitled to the presumption of innocence. If we lose sight of these fundamentals, we really do not survive as a democratic republic.
So we are the patriots, defenders of the Constitution.
Absolutely.
We have to play.
Absolutely.
We have to play by the rules.
I owe allegiance to the Constitution of India, and that will never change. And I think that makes me a patriot.
Yes. On that note, ma'am, I don't think we can thank you enough, but still for the courtesy, we really, really thank you for joining us today for this practitioner session. We know that criminal law is very complex, and as well as it's very interesting and fascinating, and that draws a lot of people towards it. However, as you mentioned, that mere interest is not enough. One must be aware of the rules, and one must be aware as to how those rules can be used in addressing and actually furthering the cause of justice. And very interestingly, as you pointed out, furthering the cause of justice for those who cannot afford it and who are institutionally excluded from it is very, very important. On that note, we thank you, ma'am, for joining us. And this is probably the first engagement of many, many more to come. And there's so much to talk to you with about the criminal justice reforms work, about how we are, dealing with in cases regarding sexual violence. So, I mean, those discussions and engagements can definitely carry on in future through this medium and different media. On that note, I would also like to thank all the participants who joined the webinar, And it was great to have all of you asking questions. And I hope that we addressed most of those questions. It is very difficult. I think one response that I got from the webinar is that, ma'am has been very, giving very detailed information about each and everything that she's discussing. So much so she's also giving a citation to the cases that she's been cited. Because I think that goes on to tell a lot about the professionalism that you exude and that you stand for. On that note, I would like to conclude this webinar, and deepest gratitude from the team of LiveLaw to Rebecca ma'am, and all the best for your cause of justice that you're fighting for. And we hope to see you again and again, standing there and defending people who do not have means to get defended and who deserve an access to justice. So thank you so much, ma'am. Thank you so much. And thank you for joining us today. Thank you.
Thank you so much.